Well, these rules one does have to be very careful with. The bankruptcy code, and this is getting at debts that have been incurred through fraud rather than post-petition fraud on the court. I said one of the kinds of debts that is problematic is a debt that's very recent. The bankruptcy code, if you're curious, in section 523A2, has a couple of benchmarks for recent debt. And they are a 90-day window and a 70-day window. And the dollar amounts change. But if you've incurred more than $650 to a single creditor during the 90-day window, there is some qualifying language about whether it's luxury goods or services, or you've gotten a cash advance or some sort of money from a creditor that exceeds $700 during the 70-day pre-petition window, then the presumption is that you didn't intend to repay the debt at the time you incurred it, and that therefore it's a debt incurred through fraud. The problem here is that sometimes people will just latch onto the time. They'll say, oh, well, it's 92 days since I incurred those debts, so I'm home free. Not really the case. It's a function of two variables, time and dollar amount. The larger the dollar amount, the more time we need to let pass before we file a petition. So I've had people come in and tell me, well, yes, I incurred $20,000 worth of new debt to a single creditor, but it was 4 months ago, so I should be home free. No, not really. That creditor is not going to go gentle into that good night. You can be absolutely sure that you will face a challenge to the discharge of that debt. So the larger the debt, the more time we need to pass before we file the petition. So we age the debt. And the aging of the debt is really a two-pronged approach. Number one, we make payments on the debt that we're aging. And number two, we let some water pass under the bridge. So one of the things we do at a first meeting is an analysis of the debts to see, is there a reason to age debts? And if so, how much aging is necessary? But that 90 and 70-day rule, one does have to be careful with, because all it's saying is if you have incurred more than a certain amount of debt, those dollar amounts do change over time. Within that window, the presumption is that the debt is not dischargeable. What it does not say is if you wait past, say, the 90 days or the 70 days, you're home free. So if you decide it's time to go max out the cards before filing for bankruptcy protection, you have decided to commit fraud, and you can be absolutely sure the creditor is going to challenge on that. In fact, I had a fellow who called up a few weeks ago, and he had $35,000 worth of credit card debt. And he said, oh, well, I want to postpone filing because I want to quickly incur another $35,000 worth of credit card debt to make the bankruptcy worth his effort. Well, that was not somebody that I was going to be taking on as a client. You don't want to be committing fraud. The slogan that's sometimes used in the case law is that a bankruptcy discharge is for the poor, unfortunate debtor, the honest, unfortunate debtor, not somebody who's trying to scam the system.